Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every Sunday from 8 to 9 a.m. to give landowners valuable information that you need regarding natural gas development here in Pennsylvania. And of course, my focus is solely on the landowner. I represent landowners in oil and gas related matters, gas lease negotiations, pipeline, water line agreements, royalty issues, royalty dispute issues, unitization issues. Are you properly unitized? Has the company appropriately credited you with the acres that you should have in the production unit? Estate planning. You hear me talking. I've been doing more and more estate planning work as prior clients now are entering into the royalty phase, starting to get some royalties and saying, hey, let's get this stuff together. We want to make sure that if God forbid something happens, that we have a succession plan in place. You do not need and should not wait until you get into the royalty phase of your lease to make sure you have all of these affairs in order, and I want to stress that. And another thing that I preach consistently is we want to make sure that your estate plan is an estate plan for you, not your neighbor, not some guy down the street or the people at the diner, at the gas station, at the church. We want to make sure that your plan is right for you. Too many people just have these cookie cutter plans, and we need to make sure that you have a plan that fits your personal situation. If you need representation regarding any of these issues and anything related to oil and gas matters, you can always contact me directly at 570-307-0702. That's 570-307-0702. And remind everybody, I represent landowners all across the state. Landowners, oil and gas rights owners all across Pennsylvania. Have clients out in Greene County, Armstrong County, Butler County, Potter, Tioga, Lycoming, you name it, where there's oil and gas related matters, either have active clients or have represented people across the state. So if you're sitting out there and you're in the western part of the state and you say, hey, maybe I'm interested in speaking with this gentleman, I use that term, gentleman. If you're interested in speaking with me, or representation, give us a call, check it out, see maybe if we are right for you. If not, hey, that's fine. But don't be afraid of distance, because it's proven time and time again never to be a factor. Just haven't had it be a factor. I have a client right now in California that I'm dealing with regularly. And again, obviously he's located in California and we communicate all the time, and there's never been any problem as far as distance. Again, I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9. Been doing the show for we're closing in on 5 years. Since August of 2010, been doing the weekly radio show, and on these stations now, Sunday from 8 to 9 a.m. Remind you also, check out pagasleaseattorney.com. That's my website. A lot of great information up there, doing more updated blogs, put these radio shows up, and we'll have this show up tomorrow, Monday. And if you're a regular listener, I do apologize. Had some things coming up. We had a holiday. Had some other things coming up where I was unable to do the show, so we had to run a few reruns. But we're back, and this show is not, well, I guess maybe I will rerun this in the future, but as of April of 2015, this is not a rerun show. So what I'm going to do today, I'm going to talk about top leases and top leasing. So as I often will say, just because I say top lease, and you may say, well, geez, I already have a lease. This doesn't matter. I'm going to tune out and go do something else. Well, certainly, hey, you're more than welcome to do that. But what I try to do is I try to make sure that every show is not just limited to that specific topic, but that when we talk about lease factors and lease terms, because you have a lease, or maybe you're interested in leasing, or certainly if you have another lease offer, there's going to be valuable information in today's show that's going to help you as well. And I'm going to talk about some pipeline issues and talk about top leases and pipelines. So that's an issue I can't say enough. Everybody needs to understand this pipeline situation. you need to understand your rights. Please do not just sign agreements. Well, don't sign any agreements. I can't even give an especially there. Don't sign a pipeline agreement. You get help. Whether it's me or somebody else, get help. It will pay off. I know it will. It does. It always does. It will pay off. Get help. Before I jump into top leases, and this kind of segues right in, accidentally actually, a couple of things I wanted to remind people. We do, I represent landowners on all types of contracts, documents, and other issues. One of the things I just wanted to shoot out some reminders to people. We see more development now occurring, obviously. So we're seeing well pads, we're seeing roadways, we're seeing pipelines. And a lot of leases will have language saying things like, if the company wants to put a well pad on your property, a pipeline, roadway, whatever the activity is, that they first must communicate with you and get your mutual consent. Mutual consent on location. Now, usually, there's a big caveat there saying mutual consent not to be unreasonably withheld by the landowner. Meaning that you as the landowner, they come out and they say, hey, we want to put this roadway here, or well site here, or pipeline at this location. You say, nah, I don't want it there. That's not where I want it. And they usually are going to say, okay, we'll provide an alternative location. And if you provide one that they don't like, whether it's a problem to construct it, whether there are wetlands in the issue, or in the area, they're going to say, well, we can't put it there for whatever that reason is. And you say, well, too bad, I want it there. And they say, well, you're being unreasonable. Very careful. Mutual consent not to be unreasonably withheld, better than not having any type of consent, but be careful. And that's another point. Make sure that if you're approached and you're having an issue, get some assistance to understand what your rights are. But my point here is, sometimes then you get to the point where you're saying, okay, you know what, maybe this is a great spot. Or even though I'm not crazy about it, I understand that it's a reasonable location and I'm going to agree. Well, the next thing that's going to happen is you're going to get a document from the company to evidence that you've agreed to that location. So you're going to sign something, and each company uses different documentation to establish that they've obtained your approval and consent for that particular location. So what we want to do, you think, oh, okay, well, hey, yeah, I approve of this well site at this location, let's say. So you say, okay, fine. So you would think that the company would give you maybe a map and say, okay, here, we need you to just sign off. I approve of this location pursuant to or as a part of the terms of my lease. Pretty simple stuff. However, generally speaking, as you may imagine, nothing is that simple. The company doesn't typically just present you this document that says, hey, I'm consenting to this location. A lot of times, they'll put in damage release information or release information. But virtually in every one of these, the company extends the contract to cover far more than just you consenting to this location. So if you have an oil and gas lease that says, I have mutual consent of approval on a well site location, and you agree to a well site location, that document that you sign should solely be limited to consenting to that particular location. You should not be agreeing to anything beyond that. And almost every company, and actually I think every company that I deal with, always puts in additional information. You can, at times, be potentially waiving indemnification or liability coverage when you sign a document which you believe is just consenting to this location. These can be very important documents. Now, different companies put more information in there, but some of them are just terrible. They give it to you under this, this guise of being this consent document when it goes so far beyond that. So please, landowners, please be careful. When you're signing a contract, when you're signing a document, you need to be on alert. You need to be on full alert every time you're signing a document to understand what it is and understand that although you have a gas lease that gives you certain rights, every time you sign another document, that document, there's a reason for it. And it's going to provide power, and a lot of times it's going to be a new agreement. So it's going to, in many cases, going to trump the gas lease. So a lot of times people will say to me, well, I have indemnification in my gas lease. Well, if you sign a new agreement, say for a roadway agreement, or depending upon how the agreement is worded, a surface site agreement for a well pad, well, you can, that contract is now taking over instead of the lease. So if you sign a roadway agreement, the company is going to install the roadway under the terms of the roadway agreement, not the lease. So if your roadway agreement doesn't have indemnification or other language that's important, but we'll stick with indemnification, well, you don't have indemnification then under the roadway agreement and for that roadway project. Please understand that. Please be very careful. Consent agreements should solely be consenting to a location. I consent to putting it there, not I consent to putting it there and I relieve you from any and all liability. So please be careful when I'm seeing that out there, and it's making me very nervous. Also, it goes along these same lines, these damage releases. So you go out, company's going to put a well pad, a roadway, whatever the case may be, pipeline, but let's stick with well pad and roadways. Well, the company comes out to you and they say, okay, we're going to pay you $15,000 for this well pad and roadway on your property. And you say maybe that's in your lease or you don't have anything in your lease, and you say, well, I'm not crazy about this, but it's a fair price. I'm really only entitled to crops and timber, so and they're not going to be worth $15,000. And remember, that's growing crops. These guys have been doing it for a while. They're not going to say you're going to be entitled to crop payments for the next 50 years where you can't plant crops in this field. It says in these leases, they all say growing crops. So those would be the crops at most that are growing at the time of these operations, not what may grow in 2 years, 5 years, 10 years. And landowners get very, very frustrated about that, and understandably, but that's part of the fact where we have to know these things. When you sign a gas lease, you need to understand that if they put a well pad in your property, you will be paid solely for growing crops, not the loss of crops. Say they take out 10 acres of fields on your property. You're not going to be paid every year for the loss of crops, only for at most 1 year. This again is a general example. We got to look at whatever your lease says, but that's very important. Well, here's my point on this. Please, when you're given damage releases, very similar to consent agreements, the companies are smart. They weave in a lot more information typically than what's necessary. So when you're signing a damage release, a surface damage release, that you're being paid, say, $15,000, and that's for crops and timber and other damage to the surface of your property. That's what the damage release should be. And a release means you're giving me $15,000. I'm giving you what's called a release, saying I am going to release you from further liability. You give me $15,000, I'm going to say to you, I'm not going to make any additional claims and say you owe me more money for damage to my surface, meaning crops, timber, other damages to the ground itself. That's what that agreement should be. You should not be releasing the company from liability for environmental issues, fines. You should not be releasing them from potential personal injury to individuals. That's not what a damage release is. You are being paid for surface damages. You're saying, I'm taking your money for the damages to my property. In exchange, I'm committing to you and I'm releasing you of any other further liability to the surface damages of my property, not if somebody gets hurt. So what we see is these documents, as always, all of these secondary contracts are going broader. Some companies make them very broad and put a lot more information in there than what should be in there. So you need to whittle that down and say, I'm only releasing what I'm being paid for. I'm not giving you a free pass on all of these other issues. And quite frankly, virtually every company does it. And hey, maybe you don't have a problem, but if you do have a problem, now you have a real serious problem. So please be careful. I am Attorney Doug Clark. You're listening to All Things Marcellus. Reminder, you can always contact me directly at 570-307-0702. We get back, I'm going to talk about top leases. It's going to be a big part of today's show, top leases, but very interesting twist with the top lease and pipeline. So stay tuned. My little teaser there. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, I'm an attorney who represents landowners, only landowners, not gas companies, not pipeline companies, not industry companies, but landowners, oil and gas right owners here in Pennsylvania. I've done literally hundreds of leases, lease reviews, pipeline agreements. I've negotiated pipeline agreements now with over 50 different companies across Pennsylvania. I say that often because I want to make sure that the listeners have a perspective of where we're coming from here, where I'm coming from, what my experience is. Doing a lot more with the states and estate work, unitization, royalty issues, royalty challenges, a lot of very interesting things going on there. So if you are looking for representation, again, I represent landowners all across the state of Pennsylvania. You can always contact me directly at 570-307-0702. 570-307-0702. Also, check out pagasleaseattorney.com. Whether you're looking for representation or looking for information, pagasleaseattorney.com. Check it out. And pipelineattorney.com. I am certainly going to be doing more pipeline shows in the future, representing a lot of landowners now. A lot of these interstate pipeline projects that do have, most likely is going to occur, they're going to have eminent domain and condemnation through these what we call FERC lines or these big interstate lines. So I have a lot of clients currently actively representing in several different projects, and there's going to be more of them, and we know there are more on the horizon. So please, again, don't just say, well, the company's going to have power of eminent domain, might as well just sign. Get information, learn your rights, maximize your circumstances, make the best of every situation you can, and you can do it efficiently and effectively, and that's how your attorney should do this for you. So you want to make sure that you're getting assistance, and get assistance from somebody with some experience that knows what they're doing. You can always contact me, but whether it's me or somebody else, please get assistance. People are taken advantage of all the time, and we want to make sure that you're not being taken advantage of. Again, I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. on these stations, and if you missed today's show, we'll have it back up. You can go to pagasleaseattorney.com tomorrow, and we'll have it up there first thing Monday morning. Okay, want to talk about top leases. What is a top lease? I've talked about top leases before, but I've been doing a lot of work recently with top leases, and especially out in Tioga County, a couple now in Potter County, but they're also in other counties as well. I just recently did one, I think it was in Washington County, a top lease file. So what is a top lease? Well, a top lease is, generally speaking, if a landowner has a current existing gas lease, which is still in effect. So say hypothetically you signed a 5-year gas lease, and that gas lease hasn't terminated. So if you signed this gas lease in 2011, that gas lease does not terminate then until potentially 2016. However, talking about terminating, you sign a gas lease in 2011, the company, we're going to use an example of a 5-year primary term or 5-year gas lease. If you sign a gas lease in 2011, well, the question is, one initial question is, well, what does the company have to do in order to allow this gas lease to continue? This is a basic concept, but I find in talking to my clients, a lot of people do not understand this concept. So I want to just take a step back and say, very, very important, fundamental, and everybody needs to understand this. If you sign a 5-year gas lease, so many people think that no matter what, that after 5 years, that lease ends. No matter what, that is absolutely not true. So what do I mean by that? So if you sign a 5-year gas lease, and we'll use for all these discussions, we'll say that you sign a 5-year gas lease on January 1st, 2011. So if you sign a gas lease 5 years, January 1st, 2011, what happens? Well, that lease is going to have a 5-year term, which we call a primary term, where the gas company has to conduct operations within that 5-year primary term. Operations being a very key word. It's really kind of a term of art in the oil and gas industry, but it's defined typically within these gas leases, within the form lease that the company provides to you. So you'll see that it'll say that it's a 5-year lease, and the company must conduct operations within that 5-year period. If they do conduct operations within the 5 years, then that lease will continue. How long will it continue? Well, potentially 50 or more years and even longer, or maybe not that long, but for a long time. It will continue. Most leases read along these lines. It says 5 years to conduct operations. If they conduct operations within 5 years, then this gas lease is going to continue as long as the company continues to conduct operations, or more importantly, as long as oil and gas is being produced or capable of being produced in paying quantities. So, one of the things that we see now, you sign a January 1st, 2011, 5-year lease. Well, one of the things we see very often is within this 5 years, when we talk about the definition of operations doesn't mean that that company has to have drilled and you get royalties within that 5-year term. Very few leases will say something like that. Normally, what it's going to say is the company has to conduct these operations within 5 years, and operations, and I'll give you on the easy side, the liberal side for the company, many times operations are simply filing for a permit, a drilling permit to drill a well that your property is going to be a part of. Now, operations, obviously, if they file a permit and they move forward and they actually drill, well, they've conducted operations. So some good leases will say the company actually has to be drilling within the 5 years. Ideally, but very rare, and you're really going to not see these very often nowadays, but saying that the company actually has to be producing gas within 5 years. So you sign on January 1st, 2011, company has 5 years to conduct operations. Well, say by the end of the 5th year, they file a permit. Let's we'll make this simple. We'll say not only did they file a drilling permit for wells that are going to include your property or a well, they're also actually drilling. So now here you are, you're sitting there 5 years later, and the company's actually drilling 5 years from the date you signed the lease. Well, that lease now, since they are drilling, is going to continue. The lease doesn't terminate. You don't get the opportunity to go back and do a new lease. That lease is going to continue. And as long as the company keeps their activity going, and then they ultimately drill a well, well, now let's say they shut that well in. Well, that well is drilled. It's capable of producing, not producing right now, but capable of producing, and maybe it's waiting for pipelines to be connected to it. Well, that can happen, and it does happen a lot, and that's something that could take several years before pipelines are connected. So to play this out, to give an idea how long these leases can last, we see so many people who are parts of units where the companies went out, they may have permitted 6 wells, and that there's no magic numbers here, but a lot of times companies permit 6 wells, sometimes 4 wells, sometimes 10 wells. But say the company permits, meaning they file permit documentation with DEP saying we intend on drilling 6 wells in this production unit. However, usually, not always, but in many, many cases, the company actually only drills 1 well. They permit 6, but they only drill 1. So you as a landowner with your property within this unit, you're going to see royalties once they start from one well. But the company does intend on drilling 5 more wells within this unit. Now, things can change over time, but we're going to use this example. So if the company drills 1 well and you're sitting there, you're going to get paid royalties based only on the well that's there and producing. So if a company then drills a 2nd well within your unit, then you now would be getting, and it starts producing gas, and you would now be getting royalties on 2 wells. But let's say these wells last, and we can use all kinds of numbers, but let's be nice to the company. Let's say these gas wells are going to last 20 years. So if they drill the first well and they permit 6, but they only drill 1. So here we are sitting there, you got 1 well drilled. Well, the price of gas is so low now, too, that none of the companies want to be very active because they would rather wait for the price of gas to go up. So if you have 1 well, and say the company decides they wait 10 years before they go and drill the 2nd well, well, now you're getting royalties from 1 well that's been drilled 10 years ago. Now you have a new well that's came online. But there are 4 more wells that the company intends on drilling, but they're not drilling them yet. Well, we can obviously, hopefully, see where this is going. Well, what if it takes another 10 years for the 3rd well to be drilled? And maybe they wait another 10 years for the 4th well to be drilled. Maybe another 10 years for the 5th well to be drilled. Well, right now, we're at 50 years. Go another 6 wells, 60 years. If that last well lasts 20 years, and that's being very, I think they're going to last longer than that, right now then you're up to 80 years of that gas lease. And if they decide to drill more wells in the future, you can see that's going to be a very long time. Now, on the flip side, rarely, but it's certainly possible that a company can come in and drill all 6 wells at once and drill that thing out and just produce. And maybe then that lease would terminate in 20, 30 years. But that's not what we're seeing. That is not what we're seeing at all. I am Attorney Doug Clark. This is All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. on these stations. And I am going to get to the top leasing, but this is a very important concept because I know there are a lot of people, I talk to people who are still confused about how this process works and what needs to occur and how long their lease is going to last. So resetting. You sign a lease January 1st, 2011. Company has 5 years to conduct operations. They start drilling a well in the 5th year. They complete the well, but your lease time has already expired. It's now January, we'll say it's February 2016, so your lease would expire. However, the company had conducted operations, so your lease now doesn't literally, we say it flips into or transitions into the secondary phase of the lease. First phase, 5 years to conduct operations. Second phase, often being called held by production. And you'll hear HBP, held by production. Can be misleading because if you're sitting out there and you had a 5-year lease and they drill a well but there's no gas being produced and that well is just sitting there capped and there's no pipelines and you're not getting any royalties, you don't quite feel that your lease is being held by production. You feel that it's being held by a well that's shut in and you're not receiving royalties, and generally people aren't happy about that situation. However, it's going to be authorized, legal, and not in violation of the vast majority, almost all leases that I see in Pennsylvania. So, sign a 5-year lease, company has 5 years to conduct operations. If they do not conduct operations in accordance to the terms of the lease, then that lease will terminate. It will end. So that's a good transition for me. What we're going to talk about is many landowners now are receiving offers for what are called top leases. So they have an existing lease. We'll stick with my example. They signed a lease on January 1st, 2011. Here we are in 2015, and a company is coming to them and saying, we want you to sign a new lease. And you say, well, geez, I already have a lease. my lease doesn't expire until January 1st, 2016. Company says, no, that's true, but we want to give you a new lease on top of the one you already have. So when that existing lease expires, this new lease will immediately take effect. So if your existing lease expires on January 1st, 2016, this top lease, which we want you to sign now in 2015, will automatically kick in on January 2nd, the same time. So there's no gap. First lease terminates, top lease kicks in, you're under lease again, under your new lease. I'm going to get into the details of the top lease, things to be looking at right after this break. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. And today's show will be up at pagasleaseattorney.com tomorrow morning. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am here every Sunday on these stations from 8 to 9 a.m. to give you the valuable information that you need as Pennsylvania landowners and oil and gas right holders. Talking today, now again, talking about several things, but transitioning here, we're going to talk about top leases. Just to reset again, in case you're just joining us, what is a top lease? A top lease is a lease literally on top of the one you already have. And what I mean, the example I'm using is, say a landowner signs a gas lease on January 1st, 2011. That gas lease has a 5-year term, meaning the company has to conduct operations in 5 years or else that lease will expire. So what we're seeing is leases are going to expire because the company has not conducted or is not going to conduct operations within this 5-year term. So what happens is, and this is really interesting stuff, because what we're seeing is companies are going out to landowners who have leases in hand that are active, and they are saying, hey, landowner, we want you to enter into a new lease. The landowner says, well, I already have a lease. The company says, yes, but we want to do what's called a top lease. So that triggers a whole bunch of questions. And these top leases take many, many forms. And even more interestingly, the company presenting you with a top lease might be the same company you already are leased to. It may be a different company. But we also know that every top lease is going to contain different terms than your existing lease. If you are leased to a company and they wanted to simply extend your existing lease, well, they would give you a document called a lease extension. Now, it could be an amendment. There's a lot of different forms it can take, but they would simply extend your existing lease. That is not a top lease. That is a lease extension. A top lease is a new lease, which is going to be on top of the existing one and not going to take effect until the existing lease terminates. So, in our example, the existing lease is going to terminate on January 1st, 2016. The company approaches you. We want you, landowner, to sign a top lease. You need to understand, who is this company and why do they want me to do this? And if I sign this, what if the first company, which is different in this example from the company now offering me a top lease, what if that first company goes ahead and conducts operations? Is that going to be a problem for me? Generally speaking, no, but we need to look at these things. Also, why would I sign, you may say yourself as a landowner, why would I sign this now and not wait until my original lease expires? Outstanding question. Outstanding question. And there's no guarantee answer to that, no set answer to that question. You need to look at your circumstances. In some cases, you may say, well, I am very concerned that if I do not sign the top lease today, that when my lease does expire, the lease that I may receive at that time may not have as good a terms as what I'm now being offered in this top lease. Also, if I don't sign a top lease, maybe I won't even get a new lease offer whenever my existing lease expires. Okay, on the flip side, well, maybe if I don't sign a top lease, let my existing lease expire, well, my new lease in the future may have better terms than what I'm being offered in this top lease. Well, again, there's no answer that I can give anyone as this set general answer to these questions. We need to look at your circumstances. Likewise, even if we look at your circumstances, I can't tell you, yeah, on January 1st, 2016, you're going to get a higher offer, so don't sign this. Nobody can tell you that. I certainly can't, and nobody else can. Nobody can. So it's about understanding what you're being presented, understanding what your options are, and making the right decision for you in these particular circumstances that you as an individual have in your case. Not what somebody else has, not what's in the message boards, but what you have as the individual landowner in this particular situation. Another enormous point is, what is the financial compensation offer of the top lease? Obviously, an enormous point. Also, well, if I sign this lease now, but it may not even take effect, but if it does take effect, it's not going to take effect until January 2nd, 2016. Well, in order to do this right, I should have an attorney. You need to have an attorney if you want to do this right. An attorney knows what they're doing. So you're going to incur expenses. So why am I going to do this? What type of money? What is in it for me? Well, generally speaking, if you're going to do a top lease, a company is going to say to you, well, if you sign this, we're going to make a commitment to give you money usually it's like within 90 days of signing, you're going to get an initial payment. But generally, that initial payment isn't the full value of the gas lease. It's going to be a lower value. I'll make up numbers for this example. Say the top lease was for $1,000 per acre bonus. The company may say, we will give you, landowner, $100 per acre within 90 days, and if we are able to take advantage of this top lease and do elect to accept this top lease come January 2016, and the first company did not conduct operations, so now our lease kicks in, then we'll give you the remaining $900 per acre, so now you have $1,000 per acre. Well, if you have a lot of acres, maybe that $100 per acre is nice. But if you only have 10 acres, now you're talking about $1,000. Sometimes, and a lot of times, you can negotiate that split. Well, I'll do the top lease, but instead of only 10% down, maybe I want 20 or 30, whatever those numbers are. You can ask for anything. Can you get anything? Well, unfortunately, you can't always get everything you ask for, but you can ask for anything. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. on these stations, talking about top leasing and some things you need to be looking at. And when you get a top lease offer, my opinion is you need to review it. You need to understand it. Generally speaking, I do a lot of consultations with top lease offers, and usually you're talking about an hour to two max to decide whether you as a landowner get the information. Is this something that you should pursue? Is it something that's right for you? And in a lot of cases, it is. Some cases, it isn't. But you need to understand. I had one recently for thousands upon thousands of dollars per acre, which a quick little side note, jumping away for a second. Gas prices. Please understand this. The companies preach low gas prices, which is true, and it's having an impact on the industry. But I just had a lease that was signed recently with the client in the western part of the state, literally one of the highest bonus especially leases I have ever done, ever in my whole career. With these gas prices, one of the highest, if not the highest, I think, bonus that I've ever been a part of as an attorney. So despite these gas prices, I'm still seeing numbers in certain areas that are very high. My point is, you can't rely on it. Every case is different. But the point is the companies know these prices are going to change. So it's a really nice self-serving thing for the landman. Companies don't like bad prices, low prices. But from a landman perspective, well, hey, shucks, landowner, price of gas is so low, market conditions, this is all we can do. Same thing with the pipelines. Look, there's some truth to it, but it's overstated. It's being overstated all the time. Stress again. As always with the show and everything I say, it's not specific advice for any specific person, but it's general advice to understand, and then you need to follow up and get detailed, specific advice for you and your circumstance. I am Attorney Doug Clark. This is All Things Marcellus, every Sunday, 8 to 9 on these stations. Also, check out PAGasleaseattorney.com. Have this show and others posted up on the website. We post them on Monday morning after we do the show on Sunday. Okay, top leases. So right now, Tioga County, very hot for top leasing. Very, very hot. Several clients, many consultations on top leasing. And one of the things, and there's so many things to look at, and I can do show upon show on this, but we need to look at that financial compensation. Here's the other thing. Okay, what are you going to get paid when you sign within 90 days, we'll say? And then what are you going to get paid in the future? We also need to look at the royalty percent. If you're sitting there and you have an active gas lease, and that active gas lease has a royalty provision of 15%, and the company wants you to sign a top lease at 12.5%, that's a hard thing to swallow. You say, well, geez, why don't I just let my current lease ride because I have 15%? And why would I sign now maybe with the same company that has me leased at 15? The same company wants me to now sign at 12.5%. Well, geez, if I sign, doesn't that almost guarantee that I'm never going to see my 15% royalty? It'll always be, if it's developed at all, at 12.5%. Well, probably. But does that mean you don't do it? Well, I can't answer that. You can only answer that when you really look at the case, look at your circumstances, and talk about the benefits and the detriments of what you're being offered, and you make an informed decision. Now, we're seeing top leases. I'm seeing top leases going out like 18 months and sometimes even longer. So you're being presented now. Your lease doesn't even expire until 18 months, and you're being presented with a top lease today. And you say, well, geez, why do I want to do that? Well, one of the things I'm going to look at very quickly, if I'm the landowner and if you're my client, is how is this payment breakdown going to be? So let's say that you're going to receive, I'm going to make up numbers here. If you're going to sign this, if you decide to do it, and you're going to get $25,000 in 90 days, if that's the way the lease is structured. So even if this lease never kicks in, you get paid $25,000 if the company accepts it. You get $25,000, and if it doesn't kick in, you keep that money. Well, maybe that's worth it for you. But you then need to also look at, what are the royalty terms? What are the future payments? What are the lease terms? You need to look at this entire package. But you need to get this information, because sometimes I look at these and I would recommend to people, look, I recommend that you go ahead and do this top lease. It's always your decision. I do not make decisions for my clients. I give them the information and allow them and help them to make decisions, but it's always your decision. Accumulate the information, get the best information available, and make the right decision. Now, sometimes these decisions are very clear. Other times, not so clear. But you need to get that information to make the right decision for you. I talked about, we're seeing these top leases sometimes going out a year, 18 months. I'm going to talk about some pipeline, an issue here with the pipeline, which I think is very interesting. I talk a lot about pipelines. I represent a lot of people with pipelines. And if you have a pipeline agreement, please get representation as soon as possible. Understand your options. Understand, do you want to sit back? Do you want to be aggressive? Understand your options and make the right decision. But think about this. I'm going to talk about this the last segment. Here you are. you have a pipeline right-of-way agreement being presented to you. Then you have a top lease presented to you, but your lease doesn't expire for another year or a year and a half. That tells me a lot as an oil and gas attorney for you and your situation, and I'm going to talk about that, so stay tuned. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here again every Sunday from 8 to 9. Check out pagasleaseattorney.com. We'll put this show up here tomorrow up at the website, and there's many other shows up there as well. And if you need representation, you can contact my office directly at 570-307-0702, 570-307-0702. Talking about top leasing, most important thing I can say, and believe me, I am very aware of this. It sounds self-serving. Oh, here's an attorney saying, get an attorney. But it's true. And I try to, take away some of that say, look, and I mean it, whether it's me or somebody else. Hey, I love representing people. I love what I do. I love working for landowners. I love fighting for landowners. I love my clients. It's a gift, and I'm so fortunate to be able to do what I do, and I love doing it. So I would love to help you if you need help, and if I'm the person to help you. But if I am not, get somebody. Get somebody. There are almost no cases that I get involved in where I say, because I don't take those cases, where I say, well, I don't feel that I helped that person. So it's not about me. Other attorneys can help you, but you need to have somebody that knows what they're doing, that you're comfortable with, and is going to work and help you in your circumstances. And it will be time and money well spent. There are times where we're able to get landowners tens of thousands and even hundreds of thousands of more dollars in compensation, but then also terms that are going to protect their property. So if you have a top lease, you need to communicate with somebody on your side working for you, not the company landman working for the company. All right. So with that said, here I want to talk about here in this last segment. There's a lot of more issues with top leases. I certainly promise you that. But here's a very interesting thing. Client, he's approached for pipeline, Tioga County. Company says, we were going to pay you $14 per foot for this pipeline in compensation and $2 per foot of easement or pipeline as damages for a total of $16 per foot. I'm going to say this quickly. I'm not telling anyone anything specific, but myself, I think that is too low of a price. And routinely, we get, close to double or more than that price in many, many areas across the state. So what happens is when people are going to sign at low prices, well, the company's going to sign them there. So they come in and they sign everyone they can at lower prices. And when people stop signing, they raise those prices up. So the company comes out, their biggest tool that they have to try to persuade landowners is, can't get gas to market without a pipeline. That's true, but doesn't mean you don't have to pay fair price to the landowner or a good market price. So they say, hey, we want you to sign this, we want you to sign this, we want to get gas, sign these pipeline agreements, you're going to get royalties. Okay, well, the landowner's the landman is preaching that to the landowner. Well, all of a sudden, after, this is some big hurry, we need to get this pipeline done, and we're saying, it's not enough money. And what happens is lo and behold, as the landman is preaching how this is so urgent and how it's going to result in these royalties in the future, well, what ends up happening? This client, in this case, landowner, gets a top lease offer from a company which his particular lease doesn't expire for about a year and a half. So there's this enormous hurry, or supposed enormous hurry to get this pipeline, but the company wants to, or a company wants to extend or a top lease because they're saying essentially, we don't think there's going to be any activity within the next year and a half that's going to hold this lease. And that being like this drilling activity, not the installation of a pipeline. So thankfully, this landowner doesn't buy into this urgency situation, which again, I'm stressing, this isn't advice for any particular person out there, but you need to look at your situation. But in this case, it becomes clear, well, hey, look, thank heavens you didn't fall into this trap and sign this agreement for this very low amount of money because, or under the belief, thinking that, well, if I sign this, I'm going to see royalties more quickly. Well, it looks like you're probably many, many years away from royalties. And a lot of these companies now, one in particular, is offering people 10-year leases. We need to hurry up and get pipelines in the ground. Oh, by the way, here's a 10-year lease. Well, listen, don't fall for that. Sign good, strong pipeline agreements. Also, interestingly, there was a major sale. I talked about it in one of the shows, I think, last month, where Southwestern sold a bunch of pipeline rights and easements to another company. I think it was for $500 million. Well, you go out there, think about this. You're a company, Southwestern, or pick a company. You go out and you buy all these pipelines at a low rate, and then you turn and you flip them and you sell them to a pipeline company at a much higher rate. So if you're a drilling company, you go out and you send your landmen out, you send out your army of landmen, you knock on all the doors of the landowners that you have leased, and you say, hey, landowners, here we are, we're going to drill, we want to get your royalties, can't get royalties without pipelines, here's pipeline agreements, $15 a foot, pick your amount, low numbers, here, hurry, here's the line, sign right here, we'll get you pipelines, we'll get you royalties. Next thing you know, that company sells all of those agreements to a third company at big profits, So they're out there. It's all part of this process, and you just need to be aware of it. But convince landowners, hey, you need to sign this. This is a good rate because this is going to get you gas to market. So sign them, say, at $15 a foot of easement. This is just for illustration. And then turn around and sell them to a pipeline company at hundreds of dollars or $100 or whatever the number is per foot. So it's just an opportunity to make money. So that's fine. We need to understand that. We live in a capitalistic society. That's what our country is about. But at the same time, you as a landowner need to be informed, and you do the same thing. I talked to a company guy. I really like this company guy, actually. I really like the guy. He's always been honest with me. He's always been straightforward. I have a lot of respect for him. We had a good conversation recently, and we were talking nothing about this, but a different situation. And we were talking about having leverage in a specific negotiation. He says, hey, look, Doug, what are we doing? What's everyone out there doing? You're looking for opportunities. And when you have an opportunity, when you're given an opportunity, you want to take advantage of it. So as a landowner, if you have an opportunity to lease and you have good leverage, well, that's an opportunity that you have now, and you need to take advantage of it and maximize it, because the company is going to do the same thing. They're going to take advantage of their opportunities, and you need to take advantage of yours. It's how it should be. There's no fault to that. And, like I said, with this gentleman, we're talking about it. He says, hey, look, I recognize your client has an opportunity here. He needs to take advantage of it. Where can we meet to get these things done? Where can we meet to get a deal done? So same thing with the pipeline. You may have an opportunity where the company really needs you and you have market power. Please know these companies are not, they're not going broke. These pipeline companies, they're not going broke. These pipelines are going to be in the ground for 50, 100 plus years. If you don't believe that, ask them to put a cap on your agreement that says this pipeline agreement terminates in 50 years. They'll never do it. Ask them to put it in to say 75 years. They'll never do it. So they're going to make money for the next 75, 100 years or whatever, pumping this gas, and you're going to get paid one time. Do not sell yourself short. Do not sell yourself short. There's nothing wrong with that. Don't buy into this. We need to pay this price. This is what we're paying people. Well, geez, how does that work? You get the first person who doesn't know what's going on, sign them at $2 a foot. And then you go to everybody else and say, oh, well, we signed this guy at $2 a foot. We want to be fair to him, so everybody has to get $2 a foot. Please, when you hear that, start questioning, well, then how come you signed one guy at $6,000 and 21% royalty, but I didn't get that? I'm up against it here. You're listening to All Things Marcellus with me, Attorney Doug Clark, of the Clark Law Firm. I'll be back next Sunday, here every Sunday from 8 to 9 a.m. Have a great week, everyone.